Hello friends, today we are going to discuss one of the most controversial topics in India, that is preventive detention. This is a topic that has been debated for years and has attracted the attention of many people across the country. So what is preventive detention? Preventive detention is an act of detention of a person without a trial or charge, with the aim of preventing from committing an offence. The Indian Constitution imposes the state and central government to use this measure when it's deemed necessary. However, preventive detention has been criticized by violating fundamental human rights, including the right to liberty and the right to fair trial. Come in this video, let's understand the different aspects of preventive detention in India, including its history and legality and controversies. The history of preventive detention in India can be traced back into the British era. The British introduced this measure to curb the Indian independence movement and to suppress political dissent. After India gained independence in 1947, the preventive detention continued to be used as a tool of maintaining law and order in the country. The first preventive detention law in India was enacted in 1950, and since then several laws have been passed by the central and state governments, including the National Security Act, the Unlawful Activities Act, and the Public Safety Act. The meaning of the word preventive detention is simple, friends. The imprisonment of a person with the aim of preventing them from committing further offence or of maintaining public order. In India, detention can be categorized into two types: punitive detention and preventive detention. Punitive detention is a punish a person for an offence which committed by him after trial and conviction in a court. Preventive detention means the detention of a person without trial and conviction by a court to prevent a person from committing an offence. It is only precautionary measure based on suspicion. Article 22 Class 3 of the Constitution allows for the preventive detention, which is the action taken to prevent possible crime. If someone is detained under preventive detention, they do not have right to personal liberty guaranteed by Article 21. To prevent the misuse of preventive detention, the Constitution provides safeguards. If the person is detained under the preventive detention, he may only be detained for 3 months at the first instance, and any extension beyond this requires approval from advisory board. Advisory board consisting of persons with qualification for appointment as a judges of High Court. Secondly, the detainee must inform the grounds of their detention, but the state may refuse to divulge this if it is in the public interest. Finally, the detainee must be given an opportunity to make a representation against detention. These safeguards are designed to minimize the arbitrary use of preventive detention. However, they are not available to enemy aliens. Today, preventive detention is used in India in various situations, including the detention of terrorists, suspected militants, and individuals involved in organized crime. The law allows preventive detention for a period up to 3 months, which can be extended approval from by advisory board. However, the use of preventive detention has been controversial. It has been criticized for being used as a political tool to silence opposition voices and for violating the constitutional rights of individuals. There have been many cases where people have been detained without valid reason and without any opportunity to defend themselves. There have been many cases of preventive detention in India which have attracted a lot of attention. One of such recent cases, Banka Snehashila versus State of Telangana, was landmark case decided by Supreme Court of India on August 2, 2021. The case challenged the constitutional validity of Section 3 Class 2 of the Telangana Prevention and Dangerous Activities Act of 1986, which empowers the government to detain a person if it is satisfied such detention is necessary to prevent him from acting in a manner prejudicial to public order. The petitioner in the case, Banka Snehashila, challenged the detention of her husband Banka Ravikant under Section 3 Class 2 of Act. Ravikant had been detained allegedly cheating and duping people of money. The petitioner argued that the detention order was illegal as it was based on mere apprehension of breach of law and order and did not show that Ravikant had actually acted in a manner of prejudicial to public order. The Supreme Court agreed with the petitioner and held that Section 3 Class 2 of the Act was unconstitutional. The court held that the power of detaining a person under the Act could only be exercised if there was a clear and present danger to the public order. Mere apprehension of breach of law and order was not enough. Banka Snehashila case is a significant victory for the right to liberty in India. The court's decision has set to clear precedent that power to detain a person under the preventive detention law must be exercised sparingly and only in cases where there is a clear and present danger to the public order. Preventive detention is a controversial issue in India. While it is necessary to maintain law and order, it is equally important to protect the fundamental rights of citizens. It is time to have constructive debate on this issue and to find solutions are in the best interest of the country and its people. So what do you think about this practice of preventive detention? If you like this video, click subscribe button to watch more such law related explanatory videos in future. See you in the next video. Thank you very much.